The Supreme Court of Canada issued a decision in 2006 known as Fiddler versus Sun Life. And in that case, they confirmed there was an obligation upon an insurance company dealing with a disability application to be fair and objective in the manner in which the claim is being assessed. Now, that includes not only the decision, how the decision is reached, but there must be a good faith assessment through every step of the claims process. And if the insurance company violates that obligation, it will give rise to two claims. One for mental distress or aggravated damages, and the second, where the conduct is reprehensible, punitive damages. I want to deal with the issue of emotional distress or aggravated damages at this moment. The awards given tend to cluster around $25, $35, maybe $50,000. There are some exceptions, but that's the general range. But in assessing how much aggravated damages should be awarded, the court will consider the economic circumstances of the individual. For example, in one case, the person had to sell her house, move in with her parents, put her furniture in storage because she had been denied the disability sums on which she could survive. Another case, because the individual had to move and relocate and incurred real estate fees of $40,000 in that process, the award of aggravated damages was set at $75,000 to adjust for these additional financial obligations upon the individual. Let's look at one case. The case is called Fernandez and Pencor. It was decided initially at trial in March of 2013. Get an idea of what kind of damages might result from these facts. The plaintiff had fallen from a scaffolding at the height of 8 feet, and a couple of days later he returned to work and again fell, this time about 3 feet. The insurer failed to pay him for 6 years, from August 2005 to September 2011. Eventually, on the last date of 2011, the insurance conceded he was entitled to the 2-year period for own occupation benefits. Keeping in mind there is this usually own occupation 2 years, any occupation beyond the 2-year period. The trial judge also found that the plaintiff was humiliated because he couldn't work and had to be financially dependent upon his common law spouse. The court also found there was never any doubt that the individual was totally disabled from performing his duties as a bricklayer, and concluded the company had ignored the detailed job description when his benefits were declined. Now, there is no professional medical evidence offered as to the impact of the failure to pay the disability benefits upon the plaintiff's life. The trial judge awarded $100,000 in aggravated damages and a further $200,000 in punitive damages. The company appealed, and that amount of aggravated damages, that is emotional suffering, was reduced to $25,000. Maybe if he had medical evidence, they could have sustained it. There is a recent decision by the Ontario Court of Appeal involving a claim for short-term disability benefits. Now, short-term are benefits paid by the employer, not an insurance company. And in that case, the trial judge found that the plaintiff had been unfairly denied 6 months of disability short-term. And the trial judge awarded $60,000 in aggravated, or another term is moral damages, because of the failure to deal with the complaint fairly. So that was a bit unusual. That decision was upheld by the Court of Appeal. In addition, the individual had been awarded $25,000 for sexual harassment. And the question was whether those two damage claims should overlap. The Court of Appeal said no, there was no overlap. There are two distinct awards, and she could keep both. And in that case, that was the case in which the plaintiff had to move in with her mother, sleep on her mother's couch, borrow money from her friends. And basically, it was in a financial crunch because the disability payments weren't made. So it's a good example of the claims that can be made when the disability application is not considered fairly. There's also something called administrative services only, where a third party pretends it's an insurance company to assess the value or the merits of the disability complaint. In one case, it was determined that the same rules would apply to the employer and to the person making the decision. There's a duty of fairness. So it's a big deal, and if you're in the middle of a disability crunch, make sure you're aware of this remedy, not only for aggravated damages, but also for punitive damages.